Hello, everyone. We're continuing part two of Regents of University of California versus Bakke. This is, again, one of the classic affirmative action cases. So, the assertion of human equality is closely associated with the proposition that differences in color or creed, birth, or status are neither significant nor relevant to the way in which persons should be treated. Nonetheless, the position that such factors must be constitutionally an irrelevance, summed up by the shorthand phrase, "Our Constitution is colorblind," has never been adopted by this court as the proper meaning of the Equal Protection Clause. Indeed, we have expressly rejected this proposition on a number of occasions. Our cases have always implied that an overriding statutory purpose could be found that would justify racial classifications. More recently, in McDonald v. Barisi, this court unanimously reversed the Georgia Supreme Court, which had held that a desegregation plan voluntarily adopted by a local school board, which assigned students on the basis of race, was per se invalid because it was not colorblind. And in North Carolina Board of Education v. Swan, we held again unanimously that a statute mandating colorblind school assignment plans could not stand against the background of segregation, since such a limit on remedies would render illusory the promise of Brown. We conclude, therefore, that racial classifications are not per se invalid under the 14th Amendment. Accordingly, we turn to the problem of articulating what our role should be in reviewing state action that expressly classifies by race. Respondent argues that racial classifications are always suspect and consequently that this court should weigh the importance of the objectives served by Davis's special admissions program to see if they are compelling. In addition, he asserts that this court must inquire whether, in its judgment, there are alternatives to racial classifications which would suit Davis's purposes. Petitioner, on the other hand, states that our proper role is simply to accept petitioner's determination that the racial classifications used by its program are reasonably related to what it tells us are its benign purposes. We reject petitioner's view, but because our prior cases are in many respects inapposite to that before us now, we find it necessary to define with precision the meaning of that inexact term, strict scrutiny. Unquestionably, we have held that a government practice or statute which restricts fundamental rights on which contains suspect classifications is to be subjected to strict scrutiny, and can be justified only if it furthers a compelling government purpose, and even then, only if no less restrictive alternative is available. But no fundamental right is involved here, nor do whites as a class have any of the traditional indicia of suspectness. The class is not saddled with such disabilities or subjected to such a history of purposeful unequal treatment, or relegated to such a position of political powerlessness as to command extraordinary protection from the majoritarian political process. Moreover, if the university's representations are credited, that is not a case where racial classifications are irrelevant and therefore prohibited. Nor has anyone suggested that the university's purposes contravene the cardinal principle that racial classifications that stigmatize because they are drawn on the presumption that one race is inferior to another, or because they put the weight of government behind racial hatred and separatism, are invalid without more. On the other hand, the fact that this case does not fit neatly into our prior analytic framework for race cases does not mean that it should be analyzed by applying the very loose rational basis standard of review that is the very least that is always applied in equal protection cases. The mere recitation of a benign compensatory purpose is not an automatic shield which protects against any inquiry into the actual purposes underlying a statutory scheme. Instead, a number of considerations developed in gender discrimination cases, but which carry even more force when applied to racial classifications, lead us to conclude that racial classifications designed to further remedial purposes must serve important governmental objectives and must be substantially related to achievement of those objectives. First, race, like gender-based classifications, too often has been inexcusably utilized to stereotype and stigmatize politically powerless segments of society. While a carefully tailored statute designed to remedy past discrimination could avoid these vices, we nonetheless have recognized that the line between honest and thoughtful appraisal of the effects of past discrimination and paternalistic stereotyping is not so clear, and that a statute based on the latter is patently capable of stigmatizing all women with a badge of inferiority. State programs designed ostensibly to ameliorate the effects of past racial discrimination obviously create the same hazard of stigma, since they may promote racial separatism and reinforce the views of those who believe that members of racial minorities are inherently incapable of succeeding on their own. Second, race, like gender and illegitimacy, is an immutable characteristic which its possessors are powerless to escape or set aside. While a classification is not per se invalid because it divides classes on the basis of an immutable characteristic, it is nevertheless true that such divisions are contrary to our deep belief that legal burdens should bear some relationship to individual responsibility or wrongdoing, and that advancement sanctioned, sponsored, or approved by the state should ideally be based on individual merit or achievement, or at the least on factors within the control of an individual. Because this principle is so deeply rooted, it might be supposed that it would be considered in the legislative process and weighed against the benefits of programs preferring individuals because of their race. But this is not necessarily so. The natural consequence of our governing processes may well be that the most discreet and insular of whites will be called upon to bear the immediate direct costs of benign discrimination. Moreover, it is clear from our cases that there are limits beyond which majorities may not go when they classify on the basis of immutable characteristics. Thus, even if the concern for individualism is weighed by the political process, that weighing cannot waive the personal rights of individuals under the 14th Amendment. In sum, because of the significant risks that racial classifications established for ostensibly benign purposes can be misused, causing effects not unlike those created by invidious classifications, it is inappropriate to inquire only whether there are any conceivable basis that might sustain such a classification. Instead, to justify such a classification, an important and articulated purpose for its use must be shown. In addition, any statute must be stricken that stigmatizes any group or that singles out those least well represented in the political process to bear the brunt of a benign program. Thus, a review under the 14th Amendment should be strict, not strict in theory and fatal in fact, because it is stigma that causes fatality, but strict and searching nonetheless. Davis's articulated purpose for remedying the effects of past societal discrimination is, under our cases, sufficiently important to justify the use of race-conscious admissions programs where there is a sound basis for concluding that minority underrepresentation is substantial and chronic, and that the handicap of past discrimination is impeding access of minorities to the medical school. At least since Green v. County School Board, it has been clear that a public body which has itself been adjudged to have engaged in racial discrimination cannot bring itself into compliance with the Equal Protection Clause simply by ending its unlawful acts and adopting a neutral stance. 3 years later, Swan v. Charlotte-Mecklenburg Board of Education and its companion cases, Davis v. School Commerce of Mobile County, McDaniel v. Barisi, and North Carolina Board of Education v. Swan reiterated that racially neutral remedies for past discrimination were inadequate where consequences of past discriminatory acts influence or control present decisions. And the court further held both that courts should enter desegregation orders which assign students and faculty by reference to race, and that local school boards could voluntarily adopt desegregation plans which made express reference to race if it was necessary to remedy the effects of past discrimination. Moreover, we stated that school boards, even in the absence of a judicial finding of past discrimination, could voluntarily adopt plans which assign students with the end of creating racial pluralism by establishing fixed ratios of black and white students in each school. In each instance, the creation of unitary school systems in which the effects of past discrimination had been eliminated root and branch was recognized as a compelling social goal justifying the overt use of race. Finally, the conclusion that state educational institutions may constitutionally adopt admissions programs designed to avoid exclusion of historically disadvantaged minorities, even when such programs explicitly take race into account, finds direct support in our cases construing congressional legislation designed to overcome the present effects of past discrimination. Congress can and has outlawed actions which have a disproportionately adverse and unjustified impact upon members of racial minorities and has required or authorized race-conscious action to put individuals disadvantaged by such impact in the position they otherwise might have enjoyed. Such relief does not require as a predicate proof that recipients of preferential advancement have been individually discriminated against. It is enough that each recipient is within a general class of persons likely to have been the victims of discrimination. Nor is it nor is it an objection to such relief that preference of minorities will upset the settled expectations of non-minorities. In addition, we have held that Congress, to remove barriers to equal opportunity, can and has required employers to use test criteria that fairly reflects the qualifications of minority applicants vis-a-vis non-minority applicants, even if this means interpreting the qualifications of an applicant in light of his race. These cannot be distinguished but simply by the presence of judicial findings of discrimination, for race-conscious remedies have been approved where such findings have not been made. Indeed, the requirement of a judicial determination of a constitutional or statutory violation as a predicate for race-conscious remedial actions would be self-defeating. Such a requirement would severely undermine efforts to achieve voluntary compliance with the requirements of law, and our society and jurisprudence have always stressed the value of voluntary efforts to further the objectives of the law. Judicial intervention is a last resort to achieve cessation of illegal conduct or the remedying of its effects rather than a prerequisite to action. Nor can our cases be distinguished on the grounds that the entity using explicit racial classifications itself has violated subsection 1 of the 14th Amendment or an anti-discrimination regulation, for again, race-conscious remedies have been approved where this is not the case. Moreover, the presence or absence of past discrimination by universities or employers is largely irrelevant to resolving respondents' constitutional claims. The claims of those burdened by the race-conscious actions of a university or employer who has never been adjudged in violation of an anti-discrimination law are not any more or less entitled to deference than the claims of the burdened non-minority workers in Franks v. Bowman Transportation Company, in which the employer had violated Title VII, for in each case the employees are innocent of past discrimination. And although it might be argued that where an employer has violated an anti-discrimination law, the expectations of non-minority workers are themselves products of discrimination and hence tainted, and therefore more easily upset. The same argument can be made with respect to respondent. If it was reasonable to conclude, as we hold that it is, that the failure of minorities to qualify for admission at Davis under regular procedures was due principally to the effects of past discrimination, then there is a reasonable likelihood that but for pervasive racial discrimination, respondent would have failed to qualify for admission even in the absence of Davis's special admissions program. Thus, our cases under Title VII of the Civil Rights Act have held that, in order to achieve minority participation in previously segregated areas of public life, Congress may require or authorize preferential treatment to those likely disadvantaged by societal racial discrimination. Such legislation has been sustained even without a requirement or a finding of intentional racial discrimination by those required or authorized to accord preferential treatment or a case-by-case determination that those to be benefited suffered from racial discrimination. These decisions compel the conclusion that states also may adopt race-conscious programs designed to overcome substantial chronic minority underrepresentation where there is reason to believe that the evil addressed is a product of past racial discrimination. Title VII was enacted pursuant to Congress's power under the Commerce Clause of subsection 5 of the 14th Amendment. Power under the Commerce Clause and subsection 5 of the 14th Amendment. To the extent that Congress acted under the Commerce Clause power, it was restricted in the use of race in governmental decision-making by the equal protection component of the Due Process Clause of the Fifth Amendment, precisely to the same extent as are the states by subsection 1 of the 14th Amendment. Therefore, to the extent that Title VII rests on the Commerce Clause power, our decisions such as Franks and Teamsters v. United States implicitly recognize that the affirmative use of race is consistent with the equal protection component of the Fifth Amendment and therefore with the 14th Amendment. To the extent that Congress acted pursuant to subsection 5 of the 14th Amendment, those cases impliedly recognize that Congress was empowered under that provision to accord preferential treatment to victims of past discrimination in order to overcome the effects of segregation. And we see no reason to conclude that the states cannot voluntarily accomplish under subsection 1 of the 14th Amendment what Congress under subsection 5 of the 14th Amendment validly may authorize or compel, either the states or private persons to do. A contrary position would conflict with the traditional understanding recognizing the competence of the states to initiate measures consistent with federal policy in the absence of congressional preemption for preemption of the subject matter. Nothing whatever in the legislative history of either the 14th Amendment or the Civil Rights Acts even remotely suggests that the states are foreclosed from furthering the fundamental purpose of equal opportunity to which the amendment and those acts are addressed. Indeed, voluntary initiatives by the states to achieve the national goal of equal opportunity have been recognized to be essential to its attainment. To use the 14th Amendment as a sword against such state power would stultify that amendment, quoting Railway Mail Association v. Corsi. We therefore conclude that Davis's goal of admitting minority students disadvantaged by the effects of past discrimination is sufficiently important to justify use of race-conscious admissions criteria. Properly construed, therefore, our prior cases unequivocally show that a state government may adopt race-conscious programs if the purpose of such programs is to remove the disparate racial impact its actions might otherwise have, and if there is reason to believe that the disparate impact is itself the product of past discrimination, whether its own or that of society at large. There is no question that Davis's program is valid under this test. Certainly, on the basis of the undisputed factual submissions before this court, Davis had a sound basis for believing that the problem of underrepresentation of minorities was substantial and chronic, and that the problem was attributable to handicaps imposed on minority applicants by past and present racial discrimination. Until at least 1973, the practice of medicine in this country was, in fact, if not in law, largely the prerogative of whites. In 1950, for example, while African Americans constituted 10% of the population, African American physicians constituted only 2.2% of the total number of physicians. The overwhelming majority of these, moreover, were educated in two predominantly African American medical schools, Howard and Meharry. By 1970, the gap between the proportion of African Americans in medicine and their proportion in the population had widened. The number of African Americans employed in medicine remained frozen at 2.2%, while the African American population had increased to 11.1%. The number of African American admittees to predominantly white medical schools, moreover, had declined in absolute numbers during the years 1955 to 1964. Moreover, Davis had very good reason to believe that the national pattern of underrepresentation of minorities in medicine would be perpetuated if it retained a single admission standard. For example, the entering classes in 1968 and 1969, the years in which such a standard was used, included only one Chicano, two African Americans out of the 50 admittees for each year. Nor is there any relief from this pattern of underrepresentation in the statistics for the regular admissions program in later years. Davis clearly could conclude that the serious and persistent underrepresentation of minorities in medicine depicted by these statistics is the result of handicaps under which minority applicants labor as a consequence of a background of deliberate, purposeful discrimination against minorities in education and in society generally, as well as in the medical profession. From the inception of our national life, African Americans have been subjected to unique legal disabilities impairing access to equal educational opportunity. Under slavery, penal sanctions were imposed upon anyone attempting to educate African Americans. After enactment of the 14th Amendment, the states continued to deny African Americans equal educational opportunity, enforcing a strict policy of segregation that itself stamped African Americans as inferior, that relegated minorities to inferior educational institutions, and that denied them intercourse with the mainstream of professional life necessary to advancement. Segregation was not limited to public facilities, moreover, but was enforced by criminal penalties against private action as well. Thus, as late as 1908, this court enforced a state criminal conviction against a private college for teaching African Americans together with whites. Green v. County School Board gave explicit recognition to the fact that the habit of discrimination and the cultural tradition of race prejudice cultivated by centuries of legal slavery and segregation were not immediately dissipated when Brown 1 announced the constitutional principle that equal educational opportunity and participation in all aspects of American life could not be denied on the basis of race. Rather, massive official and private resistance prevented, and to a lesser extent still prevents, attainment of equal opportunity in education at all levels and in the professions. The generation of minority students applying to Davis Medical School since it opened in 1968, most of whom were born before or about the time Brown 1 was decided, clearly have been victims of this discrimination. Judicial decrees recognizing discrimination in public education in California testify to the fact of widespread discrimination suffered by California-born minority applicants. Many minority group members living in California, moreover, were born and reared in school districts in southern states segregated by law. Since separation of school children by race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone, the conclusion is inescapable that applicants to medical school must be few indeed who endured the effects of de jure segregation, the resistance to Brown 1, or the equally debilitating pervasive private discrimination fostered by our long history of official discrimination, and yet come to the starting line with an education equal to whites. Moreover, we need not rest solely on our own conclusion that Davis had sound reason to believe that the effects of past discrimination were handicapping minority applicants to the medical school. Because the Department of Health, Education, and Welfare, the expert agency charged by Congress to promulgating regulations enforcing Title VI of the Civil Rights Act of 1964, has also reached the conclusion that race may be taken into account in situations where a failure to do so would limit participation by minorities in federally funded programs. And regulations promulgated by the department expressly contemplate that appropriate race-conscious programs may be adopted by universities to remedy unequal access to university programs caused by their own or by past societal discrimination. It cannot be questioned that, in the absence of the special admissions program, access of minority students to the medical school would be severely limited, and accordingly, race-conscious admissions would be deemed an appropriate response under these federal regulations. Moreover, the department's regulatory policy is not one that has gone unnoticed by Congress. Indeed, although an amendment to an appropriations bill was introduced just last year that would have prevented the Secretary of Health, Education, and Welfare from mandating race-conscious programs in university admissions, proponents of this measure significantly did not question the validity of voluntary implementation of race-conscious admissions criteria. In these circumstances, the conclusion implicit in the regulations that the lingering effects of past discrimination continue to make race-conscious remedial programs appropriate means for ensuring equal educational opportunity in universities deserves considerable judicial deference. The second prong of our test, whether the Davis program stigmatizes any discrete group or individual and whether race is reasonably used in light of the program's objectives, is clearly satisfied by the Davis program. It is not even claimed that Davis's program in any way operates to stigmatize or single out any discrete and insular or even any identifiable non-minority group, nor will harm comparable to that imposed upon racial minorities by exclusion or separation on grounds of race be the likely result of the program. It does not, for example, establish an exclusive preserve for minority students apart from an exclusive of whites. Rather, its purpose is to overcome the effects of segregation by bringing the races together. True, whites are excluded from participation in the special admissions program, but this fact only operates to reduce the number of whites to be admitted in the regular admissions program in order to permit admission of a reasonable percentage, less than their proportion of the California population, of otherwise underrepresented qualified minority applicants. Nor was Bakke in any sense stamped as inferior by the medical school's rejection of him. Indeed, it is conceded by all that he satisfied those criteria regarded by the school as generally relevant to academic performance better than most of the minority members who were admitted. Moreover, there is absolutely no basis for concluding that Bakke's rejection as a result of Davis's use of racial preferences will affect him throughout his life in the same way as the segregation of the African American school children in Brown 1 would have affected them. Unlike discrimination against racial minorities, the use of racial preferences for remedial purposes does not inflict a pervasive injury upon individual whites in the sense that wherever they go or whatever they do, there is a significant likelihood that they will be treated as second-class citizens because of their color. This distinction does not mean that the exclusion of a white resulting from the preferential use of race is not sufficiently serious to require justification, but it does mean that the injury inflicted by such a policy is not distinguishable from disadvantages caused by a wide range of government actions, none of which has ever been thought impermissible for that reason alone. In addition, there is simply no evidence that the Davis program discriminates intentionally or unintentionally against any minority group which it purports to benefit. The program does not establish a quota in the invidious sense of a ceiling on the number of minority applicants to be admitted, nor can the program reasonably be regarded as stigmatizing the program's beneficiaries or their race as inferior. The Davis program does not simply advance less qualified applicants. Rather, it compensates applicants who it is uncontested are fully qualified to study medicine for educational disadvantages which it was reasonable to conclude were a product of state-fostered discrimination. Once admitted, these students must satisfy the same degree requirements as regularly admitted students. They are taught by the same faculty in the same classes, and their performance is evaluated by the same standards by which regularly admitted students are judged. Under these circumstances, their performance and degrees must be regarded equally with the regularly admitted students, with whom they compete for standing. Since minority graduates cannot justifiably be regarded as less well qualified than non-minority graduates by virtue of the special admissions program, there is no reasonable basis to conclude that minority graduates at schools using such programs would be stigmatized as inferior by the existence of such programs. We disagree with the lower court's conclusion that the Davis program's use of race was unreasonable in light of its objectives. First, as petitioner argues, there are no practical means by which it could achieve its ends in the foreseeable future without the use of race-conscious measures. With respect to any factor, such as poverty or family educational background, that may be used as a substitute for race as an indicator of past discrimination, whites greatly outnumber racial minorities simply because whites make up a far larger percentage of the total population and therefore far outnumber minorities in absolute terms at every socioeconomic level. For example, of a class of recent medical school applicants from families with less than $10,000 income, at least 71% were white. Of all 1970 families headed by a person not a high school graduate, which included related children under 18, 80% were white and 20% were racial minorities. Moreover, while race is positively correlated with differences in GPA and MCAT scores, economic disadvantage is not. Thus, it appears that economically disadvantaged whites do not score less well than economically advantaged whites, while economically advantaged blacks score less well than do disadvantaged whites. These statistics graphically illustrate that the university's purpose to integrate its classes by compensating for past discrimination could not be achieved by a general preference for the economically disadvantaged or the children of parents of limited education, unless such groups were to make up the entire class. Second, the Davis admissions program does not simply equate minority status with disadvantage. Rather, Davis considers on an individual basis each applicant's personal history to determine whether he or she has likely been disadvantaged by racial discrimination. The record makes clear that only minority applicants likely to have been isolated from the mainstream of American life are considered in the special program. Other minority applicants are eligible only through the regular admissions program. True, the procedure by which disadvantage is detected is informal, but we have never insisted that educators conduct their affairs thoroughly through adjudicatory proceedings, and such insistence here is misplaced. A case-by-case inquiry into the extent to which each individual applicant has been affected, either directly or indirectly, by racial discrimination would seem to be, as a practical matter, virtually impossible, despite the fact that there are excellent reasons for concluding that such effects generally exist. When individual measurement is impossible or extremely impractical, there is nothing to prevent a state from using categorical means to achieve its ends, at least where the category is closely related to the goal. And it is clear from our cases that specific proof that a person has been victimized by discrimination is not a necessary predicate to offering him relief where the probability of victimization is great. Finally, Davis's special admissions program cannot be said to violate the Constitution simply because it has set aside a predetermined number of places for qualified minority applicants rather than using minority status as a positive factor to be considered in evaluating the applications of disadvantaged minority applicants. For purposes of constitutional adjudication, there is no difference between the two approaches. In any admission program which accords special consideration to disadvantaged racial minorities, a determination of the degree of preference to be given is unavoidable, and any given preference that results in the exclusion of a white candidate is no more or less constitutionally acceptable than a program such as that at Davis. Furthermore, the extent of the preference inevitably depends on how many minority applicants the particular school is seeking to admit in any particular year, so long as the number of qualified minority applicants exceeds that number. There is no sensible and certainly no constitutional distinction between, for example, adding a set number of points to the admissions rating of disadvantaged minority applicants as an expression of the preference with the expectation that this will result in the admission of an approximately determined number of qualified minority applicants and setting a fixed number of places for such applicants as was done here. The Harvard program, as those employing it readily concede, openly and successfully employs a racial criterion for the purpose of ensuring that some of the scarce places in institutions of higher education are allocated to disadvantaged minority students. That the Harvard approach does not also make public the extent of the preference and the precise workings of the system, while the Davis program employs a specific, openly stated number, does not condemn the latter plan for purposes of 14th Amendment adjudication. It may be that the Harvard plan is more acceptable to the public than is the Davis quota. If it is, any state, including California, is free to adopt it in preference to a less acceptable alternative, just as it is generally free, as far as the Constitution is concerned, to abjure granting any racial preferences in its admissions program. But there is no basis for preferring a particular preference program simply because in achieving the same goals as that the Davis Medical School is pursuing, it proceeds in a manner that is not immediately apparent to the public. Accordingly, we would reverse the judgment of the Supreme Court of California, holding the medical school's special admissions program unconstitutional and directing respondents' admission, as well as that portion of the judgment enjoining the medical school from according any consideration to race in the admissions process. Mr. Justice White, I write separately concerning the question of whether Title VI of the Civil Rights Act of 1964 provides for a private cause of action. 4 justices are apparently of the view that such a private cause of action exists, and 4 justices assume it for purposes of this case. I am unwilling merely to assume an affirmative answer. If in fact no private cause of action exists, this court and the lower courts are without jurisdiction to consider respondents' Title VI claim. As I see it, if we are not obliged to do so, it is at least advisable to address this threshold jurisdictional issue. Furthermore, just as it is inappropriate to address constitutional issues without determining whether statutory grounds urged before us are dispositive, it is at least questionable practice to adjudicate a novel and difficult statutory issue without first considering whether we have jurisdiction to decide it. Consequently, I address the question of whether respondent may bring suit under Title VI. A private cause of action under Title VI in terms both of the Civil Rights Act as a whole and that title would not be consistent with the underlying purposes of the legislative scheme and would be contrary to the legislative intent. Title II, 42 U.S.C. subsection 2000A, dealing with public accommodations, and Title VII, 42 U.S.C. subsection 2000E, dealing with employment, proscribe private discriminatory conduct that as of 1964 neither the Constitution nor other federal statutes had been construed to forbid. Both titles carefully provided for private actions as well as for official participation in enforcement. Title III and Title IV, dealing with public facilities and public education, respectively, authorize suits by the Attorney General to eliminate racial discrimination in these areas. Because suits to end discrimination in public facilities and public education were already available under 42 U.S.C. subsection 1983, it was, of course, unnecessary to provide for private actions under Title III and Titles III and IV. But each title carefully provides that its provisions for public actions would not adversely affect pre-existing private remedies. The role of Title VI was to terminate federal financial support for public and private institutions or programs that discriminated on the basis of race. Section 601 imposed the prescription that no person on the grounds of race, color, or national origin was to be excluded from or discriminated against under any program or activity receiving federal financial assistance. But there is no express provision for private actions to enforce Title VI, and it would be quite incredible if Congress, after so carefully attending to the matter of private actions in other titles of the Act, intended silently to create a private cause of action to enforce Title VI. It is also evident from the face of subsection 602, 42 U.S.C. subsection 2000 D1 that Congress intended the departments and agencies to define and to refine by rule or regulation the general prescription of subsection 601, subject only to judicial review of agency action in accordance with established procedures. Section 602 provides for enforcement. Every federal department or agency furnishing financial support is to implement the prescription by appropriate rule or regulation, each of which requires approval by the President. Termination of funding as a sanction for noncompliance is authorized, but only after a hearing and after the failure of voluntary means to secure compliance. Moreover, termination may not take place until the department or agency involved files with the appropriate committees of the House and Senate a full written report of the circumstances and the grounds for such action, and 30 days have elapsed thereafter. Judicial review was provided at least for actions terminating financial assistance. Termination of funding was regarded by Congress as a serious enforcement step, and the legislative history is replete with assurances that it would not occur until every possibility for conciliation had been exhausted. To allow a private individual to sue to cut off funds under Title VI would compromise these assurances and short-circuit the procedural preconditions provided in Title VI. If the federal government may not cut off funds except pursuant to an agency rule approved by the President and presented to the appropriate committee of Congress for a layover period, and after voluntary means to achieve compliance have failed, it is inconceivable that Congress intended to permit individuals to circumvent these administrative prerequisites themselves. Furthermore, although Congress intended Title VI to end federal financial support for racially discriminatory policies of not only public but also private institutions and programs, it is extremely unlikely that Congress, without a word indicating that it intended to do so, contemplated creating an independent private statutory cause of action against all private as well as public agencies that might be in violation of the section. There is no doubt that Congress regarded private litigation as an important tool to attack discriminatory practices. It does not at all follow, however, that Congress anticipated new private actions under Title VI itself. Wherever a discriminatory program was a public undertaking, such as a public school, private remedies were already available under other statutes, and a private remedy under Title VI was unnecessary. Congress was well aware of this fact. Significantly, there was frequent reference to Simpkins v. Moses H. Cone Memorial Hospital throughout the congressional deliberations. Simpkins held that under appropriate circumstances, the operation of a private hospital with massive use of public funds and extensive state-federal sharing in the common plan constituted state action for the purposes of the 14th Amendment. It was unnecessary, of course, to create a Title VI private action against private discriminators where they were already within the reach of existing private remedies. But when they were not, and Simpkins carefully disclaimed holding that every subversion by the federal or state government automatically involves the beneficiary in state action, it is difficult to believe that Congress silently created a private remedy to terminate conduct that previously had been entirely beyond the reach of federal law. For those who believe, contrary to my views, that Title VI was intended to create a stricter standard of colorblindness than the Constitution itself requires, the result of no private cause of action follows even more readily. In that case, Congress must be seen as to have banned degrees of discrimination as well as types of discrimination not previously reached by law. A Congress careful enough to provide that existing private causes of action would be preserved in Titles 3 and 4, and would not leave for inference a vast new extension of private enforcement power, and a Congress so exceptionally concerned with the satisfaction of procedural preliminaries before confronting fund recipients with the choice of a cutoff or of stopping discriminating would not permit private parties to pose precisely that same dilemma in a greatly widened category of cases with no procedural requirements whatsoever. Significantly, in at least 3 instances, legislatures who played a major role in the passage of Title VI explicitly stated that a private right of action under Title VI does not exist. As an indication of legislative intent, explicit or implicit, either to create such a remedy or to deny one, clearer statements cannot be imagined, and under court, an explicit purpose to deny such cause of action is controlling. Senator Keating, for example, proposed a private right to sue for the person suffering from discrimination, but the Department of Justice refused to include it, and the senator acquiesced. These are not neutral, ambiguous statements. They indicate the absence of a legislative intent to create a private remedy, nor do any of these statements make nice distinctions between a private cause of action to enjoin discrimination and one to cut off funds, as Mr. Justice Stevens and the three justices who join his opinion apparently would. Indeed, it would be odd if they did, since the practical effect of either type of private cause of action would be identical. If private suits to enjoin conduct allegedly violative of subsection 601 were permitted, recipients of federal funds would be presented with the choice of either ending what the court rather than the agency determined to be a discriminatory practice within the meaning of Title VI, or refusing federal funds and thereby escaping from the statute's jurisdictional predicate. This is precisely the same choice of words. This is precisely the same choice as would confront recipients if suit were brought to cut off funds. Both types of actions would equally jeopardize the administrative processes so carefully structured into the law. This court has always required that the inference of such a private cause of action not otherwise authorized by the statute must be consistent with the evident legislative intent and, of course, with the effectuation of the purposes intended to be served by the Act. A private cause of action under Title VI is unable to satisfy either prong of this test. Because each of my colleagues either has a different view or assumes a private cause of action, however, the merits of the Title VI issue must be addressed. My views in that regard, as well as my views with respect to the equal protection issue, are included in the joint opinion that my brothers Brennan, Marshall, and Blackman and I have filed. Mr. Justice Marshall, I agree with the judgment of the court only insofar as it permits a university to consider race of an applicant in making admissions decisions. I do not agree that petitioner's admissions program violates the Constitution, for it must be remembered that during most of the past 200 years, the Constitution as interpreted by this court did not prohibit the most ingenious and pervasive forms of discrimination against the African American. Now, when a state acts to remedy the effects of that legacy of discrimination, I cannot believe that this same Constitution stands as a barrier. 350 years ago, the African American was dragged to this country in chains to be sold into slavery. Uprooted from his homeland and thrust into bondage for forced labor, the slave was deprived of all legal rights. It was unlawful to teach him to read. He could be sold away from his family and friends at the whim of his master, and killing or maiming him was not a crime. The system of slavery brutalized and dehumanized both master and slave. The denial of human rights was etched into the American colonies' first attempts at establishing self-government. When the colonists determined to seek their independence from England, they drafted a unique document cataloging their grievances against the king and proclaimed as self-evident that all men are created equal and are endowed with certain unalienable rights, including those to life, liberty, and the pursuit of happiness. The self-evident truths and those unalienable rights were intended, however, to apply only to white men. An earlier draft of the Declaration of Independence, submitted by Thomas Jefferson to the Continental Congress, had included among the charges against the king that he has waged cruel war against human nature itself, violating its most sacred rights of life and liberty in the person of a distant people who never offended him, captivating and carrying them into slavery in another hemisphere, or to incur miserable death in their transportation thither. The Southern delegation insisted that the charge be deleted. The colonists themselves were implicated in the slave trade. The inclusion of this claim might have made it more difficult to justify the continuation of slavery once the ties to England were severed. Thus, even as the colonists embarked on a course to secure their own freedom and equality, they ensured perpetuation of the system that deprived a whole race of those rights. The implicit protection of slavery embodied in the Declaration of Independence was made explicit in the Constitution, which treated a slave as being equivalent to 3/5 of a person for purposes of apportioning representatives and taxes amongst the states. The Constitution also contained a clause ensuring that the migration or importation of slaves into the existing states would be legal until at least 1808. Article 1, subsection 9, and a fugitive slave clause requiring that when a slave escaped to another state, he must be returned on the claim of the master. Article 4, subsection 2. In their declaration of the principles that were to provide the cornerstone of the new nation, therefore, the framers made it plain that we, the people for whose protection the Constitution was designed, did not include those whose skins were the wrong color. As Professor John Hope Franklin has observed, Americans proudly accepted the challenge and responsibility of their new political freedom by establishing the machinery and safeguards that ensured the continued enslavement of blacks. The individual states likewise established the machinery to protect the system of slavery through the promulgation of the slave codes, which were designed primarily to defend the property interest of the owner in his slave. The position of the African American slave as mere property was confirmed by this court in Dred Scott v. Sanford, holding that the Missouri Compromise, which prohibited slavery in the portion of the Louisiana Purchase territory north of Missouri, was unconstitutional because it deprived slave owners of their property without due process. The court declared that under the Constitution a slave was property, and the right to traffic in it like an ordinary article of merchandise and property was guaranteed to the citizens of the United States. The court further concluded that African Americans were not intended to be included as citizens under the Constitution, but were regarded as being of an inferior order, although unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect. The status of the African American as property was officially erased by his emancipation at the end of the Civil War. But the long-awaited emancipation, while freeing the African American from slavery, did not bring him citizenship or equality in any meaningful way. Slavery was replaced by a system of laws which imposed upon the colored race onerous disabilities and burdens, and curtailed their rights in the pursuit of life, liberty, and property, to such an extent that their freedom was of little value. Despite the passage of the 13th, 14th, and 15th Amendments, the African American was systematically denied the rights those amendments were supposed to secure. The combined actions and inactions of the state and federal government maintained African Americans in a position of legal inferiority for another century after the Civil War. The Southern states took the first steps to re-enslave the African Americans. Immediately following the end of the Civil War, many of the provisional legislatures passed black codes similar to slave codes, which, among other things, limited the rights of African Americans to own or rent property and permitted imprisonment for breach of employment contracts. Over the next several decades, the South managed to disenfranchise the African Americans in spite of the 15th Amendment by various techniques, including poll taxes, deliberately complicated balloting processes, property and literacy qualifications, and finally, the white primary. Congress responded to the legal disabilities being imposed in the southern states by passing the Reconstruction Acts and the Civil Rights Acts. Congress also responded to the needs of the African Americans at the end of the Civil War by establishing the Bureau of Refugees, Freedmen, and Abandoned Lands, better known as the Freedmen's Bureau, to supply food, hospitals, land, and education to the newly freed slaves. Thus, for a time, it seemed as if the African American might be protected from the continued denial of his civil rights and might be relieved of the disabilities that prevented him from taking his place as a free and equal citizen. That time, however, was short-lived. Reconstruction came to a close, and with the assistance of this court, the African American was rapidly stripped of his new civil rights. In the words of C. Van Woodward, by narrow and ingenious interpretation, the Supreme Court's decisions over a period of years had whittled away a great part of the authority presumably given the government for protecting of civil rights. The court began by interpreting the Civil War amendments in a manner that sharply curtailed their substantive protections. Then, in the notorious civil rights cases, the court strangled Congress's efforts to use its power to promote racial equality. In those cases, the court invalidated sections of the Civil Rights Act of 1875 that made it a crime to deny equal access to inns, public conveyances, theaters, and other places of public amusement. According to the court, the 14th Amendment gave Congress the power to prescribe only discriminatory action by the state. The court ruled that the African Americans who were excluded from public places suffered only an invasion of their social rights at the hands of private individuals, and Congress had no power to remedy that. Let me read that. The court ruled that the African Americans who were excluded from public places suffered only an invasion of their social rights at the hands of private individuals, and Congress had no power to remedy that. When a man has emerged from slavery and by the aid of beneficent legislation has shaken off the inseparable concomitants of that state, the court concluded, there must be some stage in the progress of his elevation where he takes the rank of a mere citizen and ceases to be the special favorite of the laws. As Mr. Justice Harlan noted in dissent, however, the Civil War amendments and Civil Rights Acts did not make the African Americans the special favorite of the law, but instead sought to accomplish in reference to that race what had already been done in every state of the Union for the white race, to secure and protect rights belonging to them as freedmen and citizens, nothing more. The court's ultimate blow to the Civil War amendments and to the equality of African Americans claimed in Plessy v. Ferguson. In upholding the Louisiana law that required railway companies to provide equal but separate accommodations for whites and African Americans, the court held that the 14th Amendment was not intended to abolish distinctions upon color or to enforce social as distinguished from political equality or a commingling of the two races upon terms unsatisfactory to either. Ignoring totally the realities of the positions of the two races, the court remarked, "We consider the underlying fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the act, but solely because the colored race chooses to put that construction upon it." Mr. Justice Harlan's dissenting opinion recognized the bankruptcy of the court's reasoning. He noted that the real meaning of the legislation was that colored citizens are so inferior and degraded that they cannot be allowed to sit in public coaches occupied by white citizens. He expressed his fear that if like laws were enacted in other states, the effect would be in the highest degree mischievous. Although slavery would have disappeared, the states would retain the power to interfere with the full enjoyment of the blessings of freedom, to regulate civil rights common to all citizens upon the basis of race, and to place in a condition of legal inferiority a large body of American citizens. The fears of Mr. Justice Harlan were soon to be realized. In the wake of Plessy, many states expanded their Jim Crow laws, which had up until that time been limited primarily to passenger trains and schools. The segregation of the races was extended to residential areas, parks, hospitals, theaters, waiting rooms, and bathrooms. There were even statutes and ordinances which authorized separate phone booths for African Americans and whites, which required that textbooks used by children of one race be kept separate from those used by the other, and which required that African American and white prostitutes be kept in separate districts. In 1898, after Plessy, the Charlestown News and Courier printed a parody of Jim Crow laws. "If there must be Jim Crow cars on the railroads, there should be Jim Crow cars on the street railways. Also on all passenger boats. If there are to be Jim Crow cars, moreover, there should be Jim Crow waiting saloons at all stations, and Jim Crow eating houses. There should be Jim Crow sections of the jury box, and a separate Jim Crow dock and witness stand in every court, and a Jim Crow Bible for colored witnesses to kiss." The irony is that before many years had passed, with the exception of the Jim Crow witness stand, all the improbable applications of the principle suggested by the editor in derision had been put into practice, down to and including the Jim Crow Bible. Nor were the laws restricting the rights of African Americans limited solely to the southern states. In many of the northern states, the African American was denied the right to vote, prevented from serving on juries, and excluded from theaters, restaurants, hotels, and inns. Under President Wilson, the federal government began to require segregation in government buildings. Desks of African American employees were curtained off, separate bathrooms and separate tables in the cafeterias were provided, and even the galleries of the Congress were segregated. When his segregationist policies were attacked, President Wilson responded that segregation was not humiliating but a benefit, and that he was rendering the African Americans more safe in their possession of office and less likely to be discriminated against. The enforced segregation of the races continued into the middle of the 20th century. In both World Wars, African Americans were for the most part confined to separate military units. It was not until 1948 that an end of segregation in the military was ordered by President Truman. And the history of the exclusion of African American children from white public schools is too well known and recent to require repeating here. That African Americans were deliberately excluded from public, graduate, and professional schools, and thereby denied the opportunity to become doctors, lawyers, engineers, and the like, is also well established. It is of course true that some of the Jim Crow laws, which the decisions of this court had helped to foster, were struck down by this court in a series of decisions leading up to Brown v. Board of Education. Those decisions, however, did not automatically end segregation, nor did they move African Americans from a position of legal inferiority to one of equality. The legacy of years of slavery and of years of second-class citizenship in the wake of emancipation could not be so easily eliminated. The position of the African American today in America is the tragic but inevitable consequence of centuries of unequal treatment. Measured by any benchmark of comfort or achievement, meaningful equality remains a distant dream for the African American. An African American child today has a life expectancy which is shorter by more than 5 years than that of a white child. The African American child's mother is over 3 times more likely to die of complications in childbirth, and the infant mortality rates for African Americans is nearly twice that for whites. The median income of the African American family is only 60% that of the median of a white family, and the percentage of African Americans who live in families with incomes below the poverty line is nearly 4 times greater than that of whites. When the African American child reaches working age, he finds that America offers him significantly less than it offers his white counterpart. For African American adults, the unemployment rate is twice that of whites, and the unemployment rate for African American teenagers is nearly 3 times that of white teenagers. An African American male who completes 4 years of college can expect median annual income of merely $110 more than a white male who has only a high school diploma. Although African Americans represent 11.5% of the population, they are only 1.2% of the lawyers and judges, 2% of the physicians, 2.3% of the dentists, 1.1% of the engineers, and 2.6% of the college and university professors. The relationship between those figures and the history of unequal treatment afforded to the African American cannot be denied. At every point, from birth to death, the impact of the past is reflected in the still disfavored position of the African American. In light of the sorry history of discrimination and its devastating impacts on the lives of African Americans, bringing the African American into the mainstream of American life should be a state interest of the highest order. To fail to do so is to ensure that America will forever remain a divided society. I do not believe that the 14th Amendment requires us to accept that fate. Neither its history nor our past cases lend any support to the conclusion that a university may not remedy the cumulative effects of society's discrimination by giving consideration to race in an effort to increase the number and percentage of African American doctors. This court long ago remarked, "In any fair and just construction of any section or phrase of these Civil War amendments, it is necessary to look to the purpose which we have said was the pervading spirit of them all, the evil which they were designed to remedy." It is plain that the 14th Amendment was not intended to prohibit measures designed to remedy the effects of the nation's past treatment of African Americans. The Congress that passed the 14th Amendment is the same Congress that passed the 1866 Freedmen's Bureau Act, an act that provided many of its benefits only to African Americans. Although the Freedmen's Bureau legislation provided aid for refugees, thereby including white persons within some of the relief measures, the bill was regarded, to the dismay of many congressmen, as solely and entirely for the freedmen and to the exclusion of all other persons. Indeed, the bill was bitterly opposed on the ground that it undertakes to make the African American in some respects superior and gives them favors that the poor white boy in the North cannot get. The bill's supporters defended it not by rebutting the claim of special treatment, but by pointing to the need for such treatment. The very discrimination it makes between destitute and suffering African Americans and destitute and suffering white paupers proceeds upon the distinction that in the omitted cases, civil rights and immunities are already sufficiently protected by the possession of political power, the absence of which in the case provided for necessitates governmental protection. Despite the objection to the special treatment the bill would provide for African Americans, it was passed by Congress. President Johnson vetoed the bill and also a subsequent bill that contained some modifications. One of his principal objections to the bill was that they gave special benefits to African Americans. Rejecting the concerns of the president and the bill's opponents, Congress overrode the president's second veto. Since the Congress that considered and rejected the objections to the 1866 Freedmen's Bureau Act concerning special relief to African Americans also proposed the 14th Amendment, it is inconceivable that the 14th Amendment was intended to prohibit all race-conscious relief measures. It would be a distortion of the policy manifested in that amendment, which was adopted to prevent state legislation designed to perpetuate discrimination on the basis of race or color, to hold that it barred state action to remedy the effects of that discrimination. Such a result would pervert the intent of the framers by substituting abstract equality for the genuine equality the amendment was intended to achieve. As had been demonstrated in our joint opinion, this court's past cases established the constitutionality of race-conscious remedial measures. Beginning with the school desegregation cases, we recognize that even absent a judicial or legislative finding of constitutional violation, a school board constitutionally could consider the race of students in making school assignment decisions. We noted, moreover, that a flat prohibition against assignment of schools for the purpose of creating a racial balance must inevitably conflict with the duty of school authorities to disestablish dual school systems. As we have held in Swan, the Constitution does not compel any particular degree of racial balance or mixing, but when past and continuing constitutional violations are found, some ratios are likely to be useful as starting points in shaping a remedy. An absolute prohibition against use of such a device, even as a starting point, contravenes the implicit command of Green v. County School Board, that all reasonable methods be available to formulate an effective remedy. As we have observed, any other approach would freeze the status quo that is the very target of all desegregation processes. Only last term, in United Jewish Organizations v. Carey, we upheld a New York reapportionment plan that was deliberately drawn on the basis of race to enhance the electoral power of African Americans and Puerto Ricans. The plan had the effect of diluting the electoral strength of the Hasidic Jewish community. We were willing in UJO to sanction the remedial use of a racial classification, even though it disadvantaged otherwise innocent individuals. In another case last term, Califano v. Webster, the court upheld a provision in the Social Security laws that discriminated against men because its purpose was the permissible one of redressing our society's long-standing disparate treatment of women. We thus recognize the permissibility of remedying past societal discrimination through the use of otherwise disfavored classifications. Nothing in those cases suggests that a university cannot similarly act to remedy past discrimination. It is true that in both UJO and Webster, the use of the disfavored classification was predicated on legislative or administrative action, but in neither case had those bodies made findings that there had been constitutional violations or that the specific individuals to be benefited had actually been the victims of discrimination. Rather, the classification in each of those cases was based on a determination that the group was in need of the remedy because of some type of past discrimination. There is thus ample support for the conclusion that a university can employ race-conscious measures to remedy past societal discrimination without the need for a finding that those benefited were actually victims of that discrimination. While I applaud the judgment of the court that a university may consider race in its admissions process, it is more than a little ironic that, after several hundred years of class-based discrimination against African Americans, the court is unwilling to hold that a class-based remedy for that discrimination is permissible. In declining to so hold, today's judgment ignores the fact that for several hundred years, African Americans had been discriminated against not as individuals, but rather solely because of the color of their skins. So it is unnecessary in the 20th century America to have individual African Americans demonstrate that they have been victims of racial discrimination. The racism of our society has been so pervasive that none, regardless of wealth or position, has managed to escape its impact. The experience of African Americans in America has been different in kind, not just in degree, from that of other ethnic groups. It is not merely the history of slavery alone, but also a whole people were marked as inferior by the law, and that mark has endured. The dream of America as the great melting pot has not been realized for the African American. Because of his skin color, he never even made it into the pot. These differences in the experience of the African American make it difficult for me to accept that African Americans cannot be afforded greater protection under the 14th Amendment, where it is necessary to remedy for the effects of past discrimination. In the civil rights cases, the court wrote that the African American emerging from slavery must cease to be the special favorite of the laws. We cannot, in light of the history of the last century, yield to that view. Had the court, in that decision and others, been willing to do for human liberty and the fundamental rights of American citizenship what it did for the protection of slavery and the rights of the masters of fugitive slaves, we would not need now to permit the recognition of any special awards. Most importantly, had the court been willing in 1896 in Plessy v. Ferguson to hold that the Equal Protection Clause forbids differences in treatment based on race, we would not be faced with this dilemma in 1978. We must remember, however, that the principle that the Constitution is colorblind appeared only in the opinion of the lone dissenter. The majority of the court rejected the principle of colorblindness, and for the next 60 years, from Plessy to Brown v. Board of Education, ours was a nation where, by law, an individual could be given special treatment based on the color of his skin. It is because of the legacy of unequal treatment that we now must permit the institutions of the society to give consideration to race in making decisions about who will hold the position of influence, affluence, and prestige in America. For far too long, the doors to those positions have been shut to African Americans. If we are ever to become a fully integrated society, one in which the color of a person's skin will not determine the opportunities available to him or her, we must be willing to take steps to open those doors. I do not believe that anyone can truly look into America's past and still find that a remedy for the effects of that past is impermissible. It has been said that this case involves only the individual, Bakke, and this university. I doubt, however, that there is a computer capable of determining the number of persons and institutions that may be affected by the decision in this case. For example, we are told by the Attorney General of the United States that at least 27 federal agencies have adopted regulations requiring recipients of federal funds to take affirmative action to overcome the effects of conditions which resulted in limiting participation by persons of a particular race, color, or national origin. I cannot even guess the number of state and local governments that have set up affirmative action programs which may be affected by today's decision. I fear that we have come full circle. After the Civil War, our government started several affirmative action programs. This court, in the civil rights cases and Plessy v. Ferguson, destroyed the movement toward complete equality. For almost a century, no action was taken, and this non-action was the tacit approval of the courts. Then we had Brown v. Board of Education and the Civil Rights Acts of Congress, followed by numerous affirmative action programs. Now we have this court again stepping in, this time to stop affirmative action programs of the type used by the University of California. Mr. Justice Blackmun, I participate fully, of course, in the opinion that bears the names of my brothers Brennan, White, and Marshall, and myself. I add only some general observations that hold particular significance for me, and then a few comments on equal protection. At least until the early 1970s, apparently only a very small number, less than 2% of the physicians, attorneys, and medical and law students in the United States were members of what we now refer to as minority groups. In addition, approximately 3/4 of our African American physicians were trained at only 2 medical schools. If ways are not found to remedy that situation, the country can never achieve its professed goal of a society that is not race conscious. I yield to no one in my earnest hope that the time will come when an affirmative action program is unnecessary and is, in truth, only a relic of the past. I would hope that we could reach this stage within a decade at the most. But the story of Brown v. Board of Education, decided almost a quarter of a century ago, suggests that that hope is a slim one. At some time, however, beyond any period of what some would claim is only transitional inequality, the United States must and will reach a stage of maturity where action along this line is no longer necessary. Then persons will be regarded as persons, and discrimination of the types we address today will be an ugly feature of history that is instructive but that is behind us. The number of qualified, indeed highly qualified, applicants for admission to existing medical schools in the United States far exceeds the number of places available. Wholly apart from racial and ethnic considerations, therefore, the selection process inevitably results in the denial of admission to many qualified persons, indeed to far more than the number of those who are granted admission. Obviously, it is a denial to the deserving. This inescapable fact is brought into sharp focus here because Alan Bakke is not himself charged with discrimination, and yet is the one who is disadvantaged, and because the medical school of the University of California at Davis itself is not charged with historical discrimination. One theoretical solution to the need for more minority members in higher education would be to enlarge our graduate schools. Then all who desired and were qualified could enter, and talk of discrimination would vanish. Unfortunately, this is neither feasible nor realistic. The vast resources that apparently would be required simply are not available, and the need for more professional graduates, in the strict numerical sense, perhaps has not been demonstrated at all. There is no particular or real significance in the 84-16 division at Davis. The same theoretical, philosophical, social, legal, and constitutional considerations would necessarily apply to the case if Davis's special admissions program had focused on any lesser number, that is, on 12 or 8 or 4 places, or indeed only on 1. It is somewhat ironic to have us so deeply disturbed over a program where race is an element of conscientiousness, and yet to be aware of the fact that, as we are, that institutions of higher learning, I'll bet more on the undergraduate than the graduate level, have given conceded preferences up to have given conceded preferences up to a point to those possessed of athletic skills, to the children of alumni, to the affluent who may bestow their largesse on the institutions, and to those having connections with celebrities, the famous, and the powerful. Programs of admission to institutions of higher learning are basically a responsibility for academians and for administrators and the specialists they employ. The judiciary, in contrast, is ill-equipped and poorly trained for this. The administration and management of educational institutions are beyond the competence of judges and are within the special competence of educators, provided always that the educators perform within legal and constitutional bounds. For me, therefore, interference by the judiciary must be the rare exception and not the rule. I, of course, accept the propositions that A. 14th Amendment's rights are personal, B. Racial and ethnic distinctions, where they are stereotypes, are inherently suspect and call for exacting judicial scrutiny, C. Academic freedom is a special concern of the First Amendment, and D. The 14th Amendment has expanded beyond its original 1868 concept and now is recognized to have reached a point where, as Mr. Justice Powell states, quoting from the court's opinion in McDonald v. Santa Fe Trail Transportation Company, it embraces a quote, broader principle. This enlargement does not mean for me, however, that the 14th Amendment has broken away from its moorings and its original intended purposes. Those original aims persist, and that in a distinct sense is what affirmative action in the face of proper facts is all about. If this conflicts with idealistic equality, that tension is original 14th Amendment tension, constitutionally conceived and constitutionally imposed, and it is part of the amendment's very nature until complete equality is achieved in the area. In this sense, constitutional equal protection is a shield. I emphasize in particular that the decided cases are not easily to be brushed aside. Many, of course, are not precisely on point, but neither are they off point. Racial factors have been given consideration in the school desegregation cases, in the employment cases, and in United Jewish Organizations v. Carey. To be sure, some of these may be distinguished on the ground that victimization was directly present, but who is to say that victimization is not present for some members of today's minority groups? Although it is of lesser and perhaps different degree, the petitioners and United Jewish Organizations certainly complained bitterly of their reapportionment treatment, and I rather doubt that they regard the remedy there imposed as one that was to improve the group's ability to participate, as Mr. Justice Powell describes it. And surely in Lau v. Nichols, we looked to ethnicity. I am not convinced, as Mr. Justice Powell seems to be, that the difference between the Davis program and the one employed by Harvard is very profound or constitutionally significant. The line between the two is a thin and indistinct one. In each, the subjective application is at work. Because of my conviction that admissions programs are primarily for the educators, I am willing to accept the representation that the Harvard program is one where good faith in its administration is practiced as well as professed. I agree that such a program where race or ethnic background is only one of many factors. It is a program better formulated than Davis's two-track system. The cynical, of course, may say that under a program such as Harvard's, one may accomplish covertly what Davis concedes does it openly. I need not go that far, for despite its two-track aspect, the Davis program, for me, is within constitutional bounds, though perhaps barely so. It is surely free of stigma, and as in United Jewish Organization, I am not willing to infer a constitutional violation. It is worth noting, perhaps, that governmental preference has not been a stranger to our legal life. We see it in veterans' preferences. We see it in the aid to the handicapped programs. We see it in the progressive income tax. We see it in the Indian programs. We may excuse some of these on the ground that they have specific constitutional protection, or, as with Indians, that those benefited are wards of the government. Nevertheless, these preferences exist and may not be ignored, and in the admissions field, as I have indicated, educational institutions have always used geography, athletic ability, anticipated financial largesse, alumni pressure, and other factors of that kind. I add these only as additional components on the edges of the central question, as to which I join my brothers Brennan, White, and Marshall in our more general approach. It is gratifying to know that the court at least finds it constitutional for an academic institution to take race and ethnic background into consideration as one factor among many in the administration of its admissions programs. I presume that the factor always has been there, though perhaps not conceded or even admitted. It is a fact of life, however, and a part of the real world of which we are all a part. The sooner we get down the road toward accepting and being a part of the real world and not shutting it out and away from us, the sooner will these difficulties vanish from the scene. I suspect that it would be impossible to arrange an affirmative action program in a racially neutral way and have it successful. To ask that this be so is to demand the impossible. In order to get beyond racism, we must first take account of race. There is no other way. And in order to treat some persons equally, we must treat them differently. We dare not let the Equal Protection Clause perpetuate racial supremacy. So the ultimate question, as it was at the beginning of this litigation, is, among the qualified, how does one choose? A long time ago, as time is measured for this nation, a Chief Justice, both wise and farsighted, said, in considering this question, then, we must never forget that it is a constitution we are expounding. Quoting McCulloch v. Maryland. In the same opinion, the great Chief Justice further observed, let the end be legitimate, let it be within the scope of the Constitution, and all means which are appropriate, which are plainly adapted to that end, which are not prohibited, but consist with the letter and spirit of the Constitution, are constitutional. More recently, one destined to become a justice of this court observed, the great generalities of the Constitution have a content and a significance that vary from age to age. Quoting Justice Benjamin Cardozo. And an educator who became a president of the United States said, but the Constitution of the United States is not a mere lawyer's document. It is a vehicle of life, and its spirit is always the spirit of the age. Quoting Woodrow Wilson. These precepts of breadth and flexibility and ever-present modernity are basic to our constitutional law. Today, again, we are expounding a constitution. The same principles that governed McCulloch's case in 1819 governed Bakke's case in 1978. There can be no other answer. Mr. Justice Stevens, with whom the Chief Justice, Mr. Justice Stewart, and Mr. Justice Rehnquist joined, concurring in the judgment in part and dissenting in part. It is always important at the outset to focus precisely on the controversy before the court. It is particularly important to do so in this case because correct identification of the issues will determine whether it is necessary or appropriate to express any opinion about the legal status of any admissions program other than petitioners. This is not a class action. The controversy is between two specific litigants. Alan Bakke challenged the petitioner's special admissions program, claiming that it denied him a place in medical school because of his race in violation of the federal and California constitutions and of Title VI of the Civil Rights Act of 1964. The California Supreme Court upheld this challenge and ordered him admitted. If the state court was correct in its view that the university's special program was illegal and that Bakke was therefore unlawfully excluded from the medical school because of his race, we should affirm its judgment, regardless of our views about the legality of admissions programs that are not now before the court. The judgment, as originally entered by the trial court, contained 4 separate paragraphs, 2 of which are of critical importance. Paragraph 3 declared that the university's special admissions program violated the 14th Amendment, the state constitution, and Title VI. The trial court did not order the university to admit Bakke because it concluded that Bakke had not shown that he would have been admitted if there had been no special program. Instead, in paragraph 2 of its judgment, it ordered the university to consider Bakke's application for admission without regard to his race or the race of any other applicant. The order did not include any broad prohibition against any use of race in the admissions process. Its terms were clearly limited to the university's consideration of Bakke's application. Because the university had since been ordered to admit Bakke, paragraph 2 of the trial court's order no longer has any significance. The California Supreme Court, in holding that is not challenged, ruled that the trial court incorrectly placed the burden on Bakke of showing that he would have been admitted in the absence of discrimination. The university then conceded that it could not meet the burden of proving that the special admissions program did not result in Mr. Bakke's failure to be admitted. Accordingly, the California Supreme Court directed the trial court to enter judgment ordering Bakke's admission. Since that order superseded paragraph 2 of the trial court's judgment, there is no outstanding injunction forbidding any consideration of racial criteria in processing applications. It is therefore perfectly clear that the question whether race can ever be used as a factor in an admission decision is not an issue in this case, and that discussion of that issue is inappropriate. Both petitioner and respondent have asked us to determine the legality of the university's special admissions program by reference to the Constitution. Our settled practice, however, is to avoid the decision of a constitutional issue if a case can be fairly decided on a statutory ground. If there is one doctrine more deeply rooted than any other in the process of constitutional adjudication, it is that we ought not to pass on questions of constitutionality unless such adjudication is unavoidable. The more important the issue, the more force there is to this doctrine. In this case, we are presented with a constitutional question of undoubted and unusual importance. Since, however, a dispositive statutory claim was raised at the very inception of this case, and squarely decided in the portion of the trial court judgment affirmed by the California Supreme Court, it is our plain duty to confront it. Only if petitioner should prevail on the statutory issue would it be necessary to decide whether the university's admissions program violated the Equal Protection Clause of the 14th Amendment. Section 601 of the Civil Rights Act of 1964 provides, "No person in the United States on the ground of race, color, or national origin be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance." The university, through its special admissions policy, excluded Bakke from participation in its program of medical education because of his race. The university also acknowledges that it was, and still is, receiving federal financial assistance. The plain language of the statute, therefore, requires affirmance of the judgment below. A different result cannot be justified unless that language misstates the actual intent of the Congress that enacted the statute, or the statute is not enforceable in a private action. Neither conclusion is warranted. Title VI is an integral part of the far-reaching Civil Rights Act of 1964. No doubt when this legislation was being debated, Congress was not directly concerned with the legality of reverse discrimination or affirmative action programs. Its attention was focused on the problem at hand, the glaring discrimination against African Americans which exists throughout our nation, and with respect to Title VI, the federal funding of segregated facilities. The genesis of the legislation, however, did not limit the breadth of the solution adopted. Just as Congress responded to the problem of employment discrimination by enacting a provision that protects all races, so too its answer to the problem of federal funding of segregated facilities stands as a broad prohibition against the exclusion of any individual from a federally funded program on the ground of race. In the words of the House report, Title VI stands for the general principle that no person be excluded from participation on the ground of race, color, or national origin under any program or activity receiving federal financial assistance. This same broad view of Title VI and subsection 601 was echoed throughout the congressional debate and was stressed by every one of the major spokesmen of the act. Petitioner contends, however, that exclusion of applicants on the basis of race does not violate Title VI if the exclusion carries with it no racial stigma. No such qualification or limitation of subsection 601's categorical prohibition of exclusion is justified by the statute or its history. The language of the entire section is perfectly clear. The words that follow excluded from do not modify or qualify the explicit outlawing of any exclusion on the stated grounds. The legislative history reinforces this reading. The only suggestion that subsection 601 would allow exclusion of non-minority applicants came from opponents of the legislation, and then only by way of a discussion of the meaning of the word discrimination. The opponents feared that the term discrimination would be read as mandating racial quotas and racially balanced colleges and universities, and they pressed for a specific definition of the term in order to avoid this possibility. In response, the proponents of the legislation gave repeated assurances that the act would be colorblind in its application. Senator Humphrey, the Senate floor manager for the act, expressed the position as follows. The word discrimination has been used in many a court case. What it really means in the bill is a distinction in treatment given to different individuals because of their different race, religion, or national origin. The answer to this question, what was meant by discrimination, is that if race is not a factor, we do not have to worry about discrimination because of race. The Internal Revenue Code does not provide that colored people do not have to pay taxes or that they can pay their taxes 6 months later than everyone else. If we started to treat Americans as Americans, not as fat ones, thin ones, short ones, tall ones, brown ones, green ones, yellow ones, or white ones, but as Americans, if we did that, we would not need to worry about discrimination. In giving answers such as these, it seems clear that the proponents of Title VI assume that the Constitution itself required a colorblind standard on the part of government, but that does not mean that the legislation only codifies an existing constitutional prohibition. The statutory prohibition against discrimination in federally funded projects contained in subsection 601 is more than a simple paraphrasing of what the Fifth or 14th Amendment would require. The Act's proponents plainly considered Title VI consistent with their view of the Constitution that they sought to provide an effective weapon to implement that view. As a distillation of what the supporters of the Act believed, the Constitution demanded of state and federal government. As a distillation of what the supporters of the Act believed the Constitution demanded of state and federal governments, subsection 601 has independent force, with language and emphasis in addition to that found in the Constitution. As with other provisions of the Civil Rights Act, Congress's expression of its policy to end racial discrimination may independently proscribe conduct that the Constitution does not. However, we need not to decide the congruence or lack of congruence of the controlling statute and the Constitution, since the meaning of the Title VI ban on exclusion is crystal clear. Race cannot be the basis of excluding anyone from participation in a federally funded program. In short, nothing in the legislative history justifies the conclusion that the broad language in subsection 601 should not be given its natural meaning. We are dealing with a distinct statutory prohibition, enacted at a particular time with particular concerns in mind. Neither its language nor any prior interpretation suggests that its place in the Civil Rights Act, one after long debate, is simply that of a constitutional appendage. In unmistakable terms, the Act prohibits the exclusion of individuals from federally funded programs because of their race. As succinctly phrased during the Senate debate under Title VI, it is not permissible to say yes to one person but to say no to another person only because of the color of their skin. Belatedly, however, petitioner argues that Title VI cannot be enforced by a private litigant. The claim is unpersuasive in the context of this case. Bakke requested injunctive and declaratory relief under Title VI. Petitioner itself then joined issue on the question of the legality of its program under Title VI by acting for a declaratory judgment that it was in compliance with the statute. Its view during state court litigation was that a private cause of action does not exist under Title VI. Because petitioner questions the availability of a private cause of action for the first time in this court, the question is not properly before us. Even if it were, petitioner's original assumption is in accord with the federal court's consistent interpretation of the Act. To date, the courts, including this court, have unanimously concluded or assumed that a private action may be maintained under Title VI. The United States has taken the same position. In its amicus curiae brief directed to this specific issue, it concluded that such a remedy is clearly available. And Congress has repeatedly enacted legislation predicated on the assumption that Title VI may be enforced in a private action. The conclusion that an individual may maintain a private cause of action is amply supported in the legislative history of Title VI itself. In short, a fair consideration of petitioner's tardy attack on the propriety of Bakke's suit under Title VI requires that it be rejected. The university's special admissions program violated Title VI of the Civil Rights Act of 1964 by excluding Bakke from the medical issue because of his race. It is therefore our duty to affirm the judgment ordering Bakke admitted to the university. Accordingly, I concur in the court's judgment insofar as it affirms the judgment of the Supreme Court of California. To the extent that it purports to do anything else, I respectfully dissent. Well, that was a good read. As always, if there's any case you'd like me to read, just drop in the comments and I'd be happy to take a look. Thank you.